I come to you again providing some additional evidence showing just how deep the level of corruption and conspiracy runs in the state of South Carolina. And I keep referring to my March 20, 2019 public sworn testimony before South Carolina House of Representatives Oversight Committee because I wanted to create a public record of what transpired with me. I felt that my civil rights had not been protected but violated by the very agency that was supposed to do just that. So I filed a complaint against South Carolina Human Affairs Commission in Richland County Court of Common Pleas. But to give you some pre-context to the case, Judge Casey L. Manning, on February 16, 2017, he ruled on 3 motions in the absence of all parties, stating that matter has been completed prior to hearing. And that was because Attorney Eugene Matthews for South Carolina Human Affairs Commission made a request to have the case transferred to the United States District Court, Columbia Division, because of federal claims. The case went before Judge Paige J. Gossett, Magistrate Judge. And this is her reporting recommendation here, where she stated that federal claims shall be dismissed, but a single state claim shall be remanded to Richland County Court of Common Pleas. And this is just part 2 of her report and recommendation. So now the case goes before Chief Justice Terry L. Wooten. Chief Justice Terry L. Wooten accepted the report and recommendation of Judge Paige Gossett, but he made a modification. Instead of a single claim be remanded back to Richland County Court of Common Pleas, he remanded state claims. And this is just page 1 of his order, and this is page 2 of his order. I was not happy with that, but it was a win because I wanted the federal claims to remain. So I filed an appeal before the United States 4th Circuit Court of Appeal, Richmond, Virginia. In doing so, Attorney Eugene H. Matthews made fraudulent filings before the court and other courts when he stated that agencies in the state of South Carolina are not considered persons. That's a fraudulent statement, and that's a deliberate act to harm. If you look at Section 11330, Section D, it states that persons mean individuals, labor unions, and organizations. It also says that it's also or state agencies and departments and municipalities. But time and time again, Attorney Matthews would state these fraudulent statements that state agencies are not persons in the state of South Carolina. And time again, the courts would turn a blind eye to an unlawful filing, even after I had provided this law in writing and stated in motion in order to benefit South Carolina and deny a black man, due process and justice in this state. Because this state feels that a black man have no rights. So Attorney Eugene Matthews, as part of his informal brief, this is just page 1. I have not included all pages because they are numerous, but I want you to pay close attention to Section 2, where he stated that neither a state agency nor its official acting in their official capacity are persons under 42 U.S.C. 1983. I just showed you the law. So you know this is a fraudulent statement. But time and time again, he would make this claim before the court, and the court would turn a blind eye to unlawful conduct. So the justice system in the state of South Carolina is injustice in itself. The United States Fourth Circuit Court of Appeals affirmed the order of Chief Justice Terry L. Wooten, remanding state claims back to Richland County Court of Common Pleas. It was a win. It wasn't a total win, but it was a win for me. But the United States Fourth Circuit Court of Appeal issued a judgment and a mandate, remanding state claims back to Richland County Court of Common Pleas. I learned in history class in high school that the federal courts have jurisdiction over the state courts. And so when a mandate has been issued by the federal court, the state court does not have a right, does not have a choice in should we do it or should we not do it. They are to carry out the mandate as ordered. But we're going to find out that did not happen. Here's the order of the United States Fourth Circuit Court of Appeals. Here's the judgment by the United States Fourth Circuit Court of Appeal, remanding the state claims back to Richland County Court of Common Pleas. And here also is the mandate from the United States Fourth Circuit Court of Appeal as well. So I received notice of scheduling from Richland County Court of Common Pleas, notifying me that my case was on the docket for a jury trial, which I had requested. And as you can see, in the beginning, my case was 7 of 40. As time went on, my case became 6 of 31. But because of corrupt people who feel that a black man have no rights, on March the 12th, 2018, this case went before Judge G. Thomas Cooper Jr. with all parties present. On that date, Judge Thomas Cooper Jr. rejected and ignored an order of the United States Fourth Circuit Court of Appeals, a judgment and a mandate. And when I asked him about how can he just ignore and reject a mandate, he acted as though he was God. He didn't have to consider the mandate. And that's basic law 101. I'm not a lawyer, but I know that's basic law 101. But he chose to violate the mandate, and he chose to violate my right because, as I say, the state of South Carolina is a corrupt system. And this is just page 2 of his order dismissing my claim. And that really did just some confirmation. There are many other actions that took place with this case, but I just gave you the short version. But as I found out in my process, not only had I been screwed, but many other people, based on my research, has been screwed as well. And I'm going to get to that in another video. But because of corrupt people sought to deny me justice, and those parties are Judge G. Thomas Cooper Jr., Judge Casey L. Manning, Paul Gunter of Richland County Court of Common Pleas, Jeanette McBride, which is the clerk of Richland County Court of Common Pleas, and Attorney Eugene H. Matthews. The United States District Court of Columbia also violated my rights because after Richland County Court of Common Pleas would not honor the mandate of the United States Fourth Circuit Court of Appeal, I filed a motion before that court asking them to supervise the mandate, and it was denied. And that was unlawful due to the fact that Richland County Court of Common Pleas would not give me the required due process under the law. So I'm going to say something that may be not that pleasant, but it needs to be said. In 2021, we still have the white master, the house Negroes, and the field Negroes. The white slave master still violating the rights of black people. The house Negroes are still keeping their mouths shut just to have a job when they know their own people are being oppressed. And so we have a lot of work to do. A lot of work to do. We can have all the religion in the world. We can have the best job in the world. But when you sit in a position and you know that the majority of your people, or people in general, are being oppressed by those that's in power, and we keep our mouth shut, you may think man do not have a clue. But there's a God that sits high, who knows all things. And so it's up to the people of God to confront these injustices. Because when we confront injustice, we remove the oppression from God's people. But the longer we stay silent, the oppression will still continue. I am the only one that's been harmed. Justice is still required. And I'm requesting of the United States Department of Justice to investigate South Carolina Human Affairs, Attorney Eugene H. Matthews, Richland County Court of Common Pleas, and the United States District Courts. And those people are Judge G. Thomas Cooper Jr., Judge Casey L. Manning, Paul Gunter, Jeanette McBride, Judge Paige A. Gossett, Chief Justice Terry L. Wooten, because all have violated the rights of Clarence B. Jenkins, Jr. Justice is still required.